Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner of WR Immigration in our San Diego office, and I'm joined today, as always, with Miki Matrician, who's the co-managing partner of our Boston office. Good to see you today, Miki.
Hi, Kim.
So last week, we discussed site visits by USCIS's Fraud Detection and Nationality Security Unit, the FDNS. And for today's installment, we are discussing site visits by Immigration and Customs Enforcement, also known as ICE for short. Given the administration's focus on enforcement and anticipated compliance reviews, this is a timely topic to address with global mobility and HR professionals. ICE is the agency that focuses on immigration enforcement, including deportation operations and I-9 investigations or inspections, as well as managing the CVIS program for F, M, and J students. So as we talked about during last week's Rapid Fire Wednesday, the focus of the administration is immigration enforcement. As I think most of us have seen in the news lately, there's been a lot of coverage on what's going on from that perspective with deportations. So there has been much talk about the ICE arrests and detention of both documented and undocumented immigrants. And there is a lot of fear that is important to dispel misinformation. In today's session, we hope to provide information that can empower people. So today, Miki, can you tell us what we should know about ICE's enforcement actions?
Yeah, so we are hearing of actions by ICE happening across the country. And ICE has been given a directive to meet a quota of 1,200 arrests nationally per day. And there are 25 ICE field offices. So that means each office has been directed to make at least 75 arrests per day. And that's what we understand is at the threat of being fired if they don't meet the quota. For mobility professionals, what is really important to know is that ICE can't just come into your private workplace. If it's a public area like a lobby or waiting area, ICE can enter just as any member of the public could. But if they want to enter a private area, they need a judicial warrant or consent by the company representative.
Yeah, so there are two kinds of warrants, right? A judicial warrant and an administrative warrant. So Mickey, can you tell us what the differences are between those two and why it actually matters?
Sure. So a judicial warrant is one that is issued by a federal or state court and signed by a judge. And it would name specific people that they're going after for specific location or documents. And that type of warrant would have, like a building number, room number, usually. These are usually issued only for criminal issues or for investigations. On the other hand, an administrative warrant presented by ICE is typically issued by the Department of Homeland Security for investigations into civil immigration violations and not for a crime. And it's important to know that it's not enforceable in a court of law and isn't required to be followed. So you can ask the agents to politely and simply leave. What I tell my clients is your front desk person should ask to see the warrant and review it to determine the type and the scope of the warrant.
Right. So ICE can come into a workplace not just to try to check for undocumented immigrants, as we've been seeing in some occasions. They could actually come to audit an employer's I-9 documents. And this type of enforcement action is separate from the actions in which they serve a warrant for an individual, a specific individual, or to search the premises or seize documents. So if they are there for an I-9 audit, Homeland Security Investigations, which we typically refer to as HSI, usually shows up with an auditor and an agent, and they issue the notice of inspection in person. So they typically travel in twos, and they walk into the office, and they will have that NOI, notice of inspection document in hand to serve to the company. So during COVID, they were issuing some NOIs via email for health reasons, right? But we expect a lot more of these coming up in the next few months or so, and they should be most likely presented in person. So when ICE does come on or to a workplace for an I-9 audit, the company representative that is there should review the document that is issued, make sure the correct legal name of the company is stated on the notice of inspection. And if not, then that representative should not sign the NOI and should ask HSI to please correct the legal name and issue a new notice of inspection. And it's amazing how many of these NOIs actually have incorrect legal names on them. So it's a common mistake that we see. Maybe they will correct that, but that's what we've seen a lot in the past several years. So this notice of inspection is typically accompanied by an administrative subpoena that asks for documents needed for the I-9 audit. And those are documents that are separate from the Forms I-9. So the documentation may include such things as the business license, the incorporation or formation documents of the organization, payroll records, and the payroll records are to make sure that the company does provide all of the active employees I-9s, right? So they're doing a matching game using those payroll records, as well as using them to document and make sure that the first day of employment is correct on the Forms I-9. Some other documentation that they might ask for are E-Verify records and any kind of Social Security no match letters, as well as documentation related to training of on the I-9 process or E-Verify process that employees have taken at the company. And they might also ask for any kind of written handbook or guidance that the company has provided to employees on the I-9 process. So these documents are typically not required to be presented within 3 days, like the Forms I-9 are. And that's one thing to look at. The notice of inspection, has a section where it asks the employers if they want to waive their 3-day notice, which in essence means turn over the I-9s now. Never ever waive that 3-day notice. It's really important to make sure that you keep the 3-day notice so you turn over the I-9s after 3 business days. And then the documents in the administrative subpoena are usually turned over at a later point in time, depending on just coordinating with the auditor or the agent. So after all that information about the I-9 audits, just a quick summary of what to expect. Miki, what are your tips for employers in advance of I-9 audits?
Yeah, first and foremost, just to do an internal audit of your Forms I-9 and any supporting documentation. And if don't feel like you're experienced in doing a self audit, engage your immigration counsel to assist with that. The minimum action that employers should be taking, first of all, is to ensure that there is a completed Form I-9 for every active employee. And if not, complete the I-9 process for those employees. And then employers should also make sure that temporary work authorization is valid. So, for instance, if an employee presented an EAD card, ensure that that period of work authorization hasn't expired. And if it has, the work authorization needs to be re-verified as soon as possible. And this also applies to non-immigrant sponsored classifications like the H-1B, TN, L1, etc. And it is not sufficient just to extend the status by a petition or application. The Form I-9 Supplement B also has to be completed to document that re-verification of the employment authorization. And you can, in terms of the audit, you can start with a spot check or a segment of your I-9s, and then you can decide if it's in good shape and you will do a comprehensive check. Make sure to purge files of terminated employees that are beyond the retention period so the government can't penalize you for mistakes that you made on old records. The retention period for Forms I-9 of terminated employees is 1 year after the date of termination or 3 years after the first date of hire, whichever is later. It's really important to never purge Forms I-9 and supporting documentation for active employees.
Yeah, totally agreed. And that's an important point. Always make sure you have I-9s for active employees. And I would also add that an employer should make sure that the front desk is trained on how to handle government visits, right? So the company should have a plan in place so that the team members know what to do, what questions to ask, and who to contact if ICE comes knocking at the door. There also have been companies approached by ICE with administrative audits that are not notice of inspection, and they ask to see the documentation or the employees. So always consult with counsel, and company representatives should note that they may accept the administrative warrant, but the company may determine after reviewing it, depending on what's being requested, that they will not comply unless ICE obtains a court order or a judicial warrant. So those are some things to consider with actions being taken by ICE, and just being very aware of what's being provided by the government officials and who on the team is responsible for what, so that everybody can act in an orderly way and protect the company and the employees. So I think that's a wrap for today's session on ICE enforcement actions. And stay tuned for future episodes on updates to the immigration landscape. If you don't already do so, please follow WR Immigration on LinkedIn, as well as Miki's individual profile and my profile. And we transcribe this and post it to a newsletter every week that you can subscribe to and read and just digest at your own speed. So good to see you, Miki, and hope that we'll see you again soon.
Good to see you, Kim.